Okay, so when I got to put it up on the screen, this chapter 17 is involuntary transfers, and actually tonight's class is going to be pretty quick. They're short chapters. But when I talk about an involuntary transfer, what does that mean to you? You didn't want it to happen. You weren't volunteer. You weren't trying to make it happen. Not your choice. So what kind of things would be involuntary transfers? Okay, you didn't pay something, whether that was voluntary or involuntary or not. You weren't of means to pay something, so they took property from you. What other kinds of involuntary transfers?
Condemnation.
Condemnation, eminent domain. He's smiling because sometimes they're a big part of that. Because when he does work for Duke Energy, who's he really doing work for? When you do work for Duke Energy, who are you really doing work for? But it's for the public good. So that's their biggest argument they use. We want to have the right to be able to run this line or take this property or do whatever because we got to extend utilities down to the people beyond and we're servicing so many people. That is definitely public good. So you think about how you have utilities today. We very much take all of that. We assume we get it. Go to Puerto Rico right now and you'll never assume that you should have it anymore. You have a totally different opinion about it. So through a public taking through a condemnation, depending upon what kind of condemnation is it for public utilities versus for redevelopment. What other voluntary transfers do we see? No, I'll take a break.
Oh, okay.
Since everybody's here, I'll take a break. But I'll take a break in a few minutes, but I'm going to start this. What other involuntary transfers do we see? How about when somebody dies? That's like totally involuntary, unless they commit suicide. But even at that point, they probably didn't want to do it anyway. But so involuntary transfers, they happen because we're not choosing them to happen. And it's a transfer title of land without an owner's consent. So we didn't voluntarily sign the deed over. We didn't go into a contract to do all this stuff. We have something called adverse possession. It's the acquisition of the title to real property by means of wrongful occupancy for a period of time established by statute. Now, when I was taking this class years ago, I thought adverse possession not only meant that you had to adversely possess property, but you should be paying taxes on it. You should be utilizing it and doing other things like that. It's not. It's not that whole bundle of wax. It really just means that, and we'll go through what adverse possession means and when it does not apply, and then the purpose of adverse possession. Why does something called adverse possession ever even exist in our society? And then eminent domain. Obviously, it's the power of government to take private property for public use with just compensation afforded to the property owner. What's just compensation? If somebody was going to come to you and take your property, what would you think just compensation would be?
Fair market value.
It's never enough. It's all, oh God, if it's duped, the dollar signs are huge. That's like when I worked for McDonald's. I never told anybody I worked for McDonald's. The dollar signs are huge.
How much that costs?
Okay. Fair market value. So this is another reason appraisers get work, because appraisers are hired and they don't just want broker's opinion record. When it has to go to court, when there's a fair market value determination, they want official formal. Last night we did appraisal.
It's required by law.
It's required by law, but and also so the state and stuff like that. So another reason for appraisers to exist, the eminent domain happens more often than you realize. We're not using it as a way to redevelop stuff as much as, but it's still happening because we still widen roads, we still do utilities. There's still things we need for our infrastructure, for government, for a society to live and survive. So we're still doing condemnation proceedings. Just compensation, the award the owner is entitled to when property is taken by the government under its power of eminent domain, measured by the property's fair market value. So that's what we're trying to achieve, is a fair price, fair payment. Now, if somebody's going to take half your front yard and it's no longer usable, what's half your front yard worth? Is it worth all of your house? No, it's worth half your front yard, but you still have a backyard to use, so it's only worth a quarter of your total land acreage. You know, how is somebody going to look at that? That's why we hire an appraiser, to make those decisions and justify those decisions. The reason I do the half front yard, in our neighborhood, they went through and they cul-de-sac several streets. Yeah.
I still remember on the test 10 years ago that eminent domain and what is it, the other condemnation.
Same thing.
They was just so tricky though,
But eminent domain and condemnation are the same thing. They're synonyms.
but they worded it where you had to either choose eminent domain or condemnation.
They're really the same kind of thing. They're really the same kind of thing. And I don't know if you're going to see a test like that today. It's really the same prospect. After the same thing. No. The reason in my neighborhood, they cul-de-sac a lot of streets. In order to cul-de-sac streets, they had to literally make turnaround areas. In order to make turnaround areas of 2 lanes, they had to go into people's front yards. And literally take half their front yards to be able to have an area that, especially if a fire truck got to the end of the street and had to turn around, it has to be wide enough to be able to get that fire truck to turn around and come through. So in my neighborhood, when you drive to where these cul-de-sacs are now, there's a lot of people literally missing half their front yards. So they were paid by the village or state, whatever, wherever they got their money. This was lots of grant money that they got to do this, but they did pay all those people this fair market value for the use of their yards. They put some landscaping up. They put fences up where they had to make it look pretty. When you're us in the neighborhood, we think it's screwy, but it happened. But that's, again, fair market value. How do you judge what it is? That was what they had to do. Kelo and its aftermath. Kelo was a big case that started to prove eminent domain, to say that the cities could take property if the property was in a state of disrepair. They could come in and they could take the property and they could redevelop the property for economic development purposes. So in Kelo, they took her property to put a pharmaceutical building up. They wanted to put an office building there for this pharmaceutical company. And they went after it. She appealed it. It went to the Supreme Court, National Supreme Court, and they ruled that they were allowed to do this in terms of economic development, to be able to use the Kelo case to back this up. Well, Kelo happened, and then a few years later, something called Norwood in Cincinnati happened. When Norwood in Cincinnati happened, the developers came through and they offered 75 property owners what they considered more than fair market value for their property. They actually came in and they offered all these people 2 and 3 times what their property was worth, because they weren't offering for their properties if it was residential. They were trying to take 3 blocks of residential and turn it into retail commercial. So they were already offering people what would be a retail commercial price for their property. I think the developers were very fair in what they were offering. And they had 70 out of 75 absolutely said, yes, son, where do we sign? Can't sign fast enough. And a lot of these people got $200,000-$300,000. It was the biggest financial gain a lot of these people would ever see. To get that kind of price for their property, it gave them a chance to literally move on, move elsewhere, and go on. So that meant 70 out of 75 took it right away. 5 kind of held back. 3 property owners ended up going to the Ohio State Supreme Court. It never went to federal. And the reason it didn't go to federal is because it was everything was state, all within the state. It wasn't an out-of-state owner trying to do it. It was all within the state. So under the jurisdictional rules, laws, it's all within the state. And so that's why it went to Ohio Supreme Court. And what happened is they went in. Norwood made the decision. By the way, how many of you know that Rookwood is in Norwood and not Oakwood? Okay, so Norwood went in and said, we're going to take the property. We're going to say that it's in state of disrepair. And we're going to take this property where these 75 property owners live, and we're going to turn it over to this developer to build Rookwood 3. Economic development at its best. Take this little shabby neighborhood and turn it into a hotel, office building, retail, fancy restaurants, eminent domain at its best, what we can do for economic development. And so they went on and they pushed. The final holdout, the one that got the most money, was a guy who said he owned a 2-family that had been given to him by his family. And it really was about money. They offered him probably $400,000 or $500,000. It ended up going to the state Supreme Court. The state said, no, Norwood, you can't do this. You cannot take this private property and turn it over to another developer. Now, if Norwood had come in and said, wait a minute, we're going to take this property, we're going to do economic development, and the city of Norwood's going to continue to own the land, it might have ruled the other way. But what the city of Norwood had tried to do is they said, no, we're going to turn this property over to Anderson and their partners. So we're taking from these private people, we're turning it over to another private group, and we're going to let them do this redevelopment. Who's going to make the money in the end? Another private developer. not the city of Norwood. If it had stayed the city of Norwood, I really think it could have stayed, and they probably, based on the Kelo case and decisions, they probably could have gone on. So the state of Ohio said, no, you can't do it. You can't take private property, turn over a private developer. The guy who owned the two-family ended up getting $1.6 million for his two-family. Through this whole process, he ended up with a divorce, so he probably only got half of that anyway, much less what the attorneys got. Another family, trying to think, it was an older couple that owned another house. They had raised their kids there. They wanted to die in the house, and you really felt for them. This was really what eminent domain, the fight, is all about. These people bought a house. They owned a house. They should have the right to raise their family and die in this house. Through this whole stress of everything, he ended up getting cancer. He's now dead. They got several $100,000 more for their house, but they still lost their house. And then the other group that got it was the Kumon Learning Center that ended up with several $100,000. The way I feel about this is if you had a majority, an overwhelming majority that said, hey, let's go for it, it probably should have gone through and not had to go this far. But we have private property rights. Those private property rights are protected, and that's what this was pushing against. No matter how much money you're paid, you have the ability as a property owner to say no, and that's what this is all about. So the aftermath is we've had more decisions, and in our textbook it actually talks about the Norwood case. Transfer of property on death. Intestate succession is distribution of property of a person who dies without leaving a will or whose will is invalid. So how is a will invalid?
It's not in writing.
It maybe the person that did it was senile and they can prove they were senile. They shouldn't have been doing it. Wills don't necessarily have to be in writing, but we prefer they be in writing. It's easier to track them. But if some family member has told his son that for the last 40 years, I'm going to give you this property, I'm going to give you this property, I'm going to give you this property, and then he dies, never does a will, who should get the property? Everybody in the family knows the intent was there, and that's the kind of thing they'll bring to the court. So the historical background of this property on death, it is, English law. It's statutes of descent and distribution that provide for the distribution of property to a person who dies without a valid will. They do something called per stirpes distribution of intestate property to persons who take share allocated to a deceased ancestor. So if you die without a will, the state's going to take over the property, but the state will go out and try to find heirs. They'll advertise, they'll do investigation, and they'll try to find heirs. When they find heirs, the brother, the sister, the nieces, the nephews, the parents of whoever died without the will, then they divide the estate. That's where the per stirpes comes in. They divide the estate. They have some kind of scientific formula that says kids get this and cousins get this, and that's what they're trying to do to kind of go there. And then they'll go a step further and do per capita. This distribution of intestate property to persons who take equal shares as members of a class. Not as representatives of the ancestor, but they'll say, oh, you're a class of people, you're this charitable organization, but you're specific people, and then therefore now we're going to divide it per capita. And then we have the whole order of distribution. Again, that's all common law, kind of historical law of how we're going to distribute property. And then we have a sheet, which is reversion of the property of the state when a person dies intestate with no heirs or when the property is abandoned. So when there's a sheet, which is truly they can't find anybody, the state literally will liquidate the property. And the state does not want to hold property long. They will liquidate the property. The state is a very bad keeper of real estate. So they will liquidate the property. They'll sell it, and the money will go in the state treasury.
Professor, so but this, if when somebody dies, if the family hires an estate attorney and they go through the process of naming like an executor or whatever, then the state never takes over the property.
If there was no will, the state will go through a process to settle this up through the probate courts.
Oh, okay.
Even if, so in a will, they'll name an executor. Or the executor is somebody who has legal authority to act on behalf of somebody, a power attorney or whatever, or they've been named an executor. But if they don't have a will, they typically haven't gone that far to get an executor either. The executor is part of this planning process. So if people don't plan a will, don't do it, who's the executor of the state? So that's when it goes to the probate court. The probate court helps settle.
Right. So the will is not just about like who you want this to go to or who you want that to go to. You should name the executor first.
you should name an executor. You want to name a relative or somebody that you trust that's going to give the assets out the way you anticipate, that's going to follow your word, your dreams, your wishes. That's what the job of the executor is to do.
Usually a payment, right?
There's a payment for the executor. Yeah, my brother is the executor of my parents' estate. I used to be. Now it's him. He's there every week taking care of them, helping my dad keep his bills paid and everything. And I just assume it's down in Florida. I just assume when something happens to my parents, my brother can take care of it. He's physically down there with them. Yeah, they're going to ship stuff back up here to me. Their cemetery is at Spring Grove. Well, they were Cincinnati natives, so they still want to come back, but they'll come back in urns. They've already got this all planned out, but there's things that have to be taken care of in Florida. He's got a bank account. They've got property. They've got things like that. So that's what my brother's job is in Florida to do, to take care of that. I don't have to physically go down there. He's down there to do it. If my brother wasn't there, then they would, through the attorney, they would name an executor. And typically an executor is an attorney. If it's not a family member, usually it's an attorney that'll help out.
And then there's a dower too.
Dower is part of the whole distribution, the order of distribution. It would be figured in the whole distribution channel. The dower rights are protected. Yes, somebody dies without a will, there's dower rights. The dower gets protected. That's the first person to get something, and then children. And yeah, without a will, they're going to go through to the family first, and then they'll do distribution that way. So without a will, everything is going to go to probate, then a judge or somebody's going to decide where things are going. So that's the reason for making a will. So testate succession. Okay, so the person dies leaving a will. Here's what does happen. They have a will, a written instrument that permits distribution of their property after they die. Has to contain certain elements. They have to be a sound mind. It should be written. It should be signed. It should be witnessed, and it should be attested. So witnessed is when they have somebody else sign it there. Attestation is having a notary or attorney actually stamp it to say that it's been through this formal process. There's family protection. Elective shares, the share of deceased spouse's estate that the surviving spouse may claim if the decedent spouse will did not provide at least this amount. So that's dower, is the elective share. So testate, again, they recommend the will be in writing. It doesn't have to be. They have been challenged without. And they're challenged when they're in writing, too. Many families challenge the wills that are in writing because they think that somebody was taking advantage of somebody to get them to change that will at the last minute. They're going to say, are they of sound mind? Did they write it? Is this really officially their writing, their signature? And when they didn't have it attested or something happened. So a lot of times wills can get challenged as well. So when estates get administration of estates, it's a general term used to describe the management and settlement of the decedent's estate by a person appointed by the courts. The probate court is going to have proof that the instrument is genuine and it is the last will and testament of the maker. And obviously, what's proof of death? Death certificate. So they're going to have the death certificate filed as well. Now, when my father-in-law died, he'd already given everything to his wife, my mother-in-law. The attorney filed all the probate paperwork. All we did was go sit down and have a meeting with the attorney, and everything was sent back. Documents were changed. The house was put in her name fully. But we never had to go do anything more with probate. It was all done. He died. He was 91. They'd been together for a long time. My mother-in-law is still healthy, 89, almost 90. But they had a plan. So this whole probate process, it was quickly an attorney just filling some paperwork in. It was already done, already planned. Very easily done. I had to take her around to Social Security, call Cincinnati Bell, because he's a retiree, and do a bunch of things to help her get all of her stuff done. But it was already planned. So it was easily done. In a couple weeks, we had everything done. So when you plan, you can get it done right. All right. I think that's the end of that chapter. Yes. So any questions about involuntary transfers?